Welcome back. The second week in the federal trial on the alleged plot to kidnap Governor Whitmer wrapped up this afternoon. We only had 2 days in court this week after a positive COVID case delayed the trial, but we still have a lot to talk about. Joining me in the studio, we have former U.S. Attorney for the Western District of Michigan, Patrick Miles, and Tanya Kraus-Phelan, who teaches criminal law at WMU Cooley Law School. Thank you both for coming back. Obviously, there was a big delay with that COVID case. What kind of impact does that have when you try and get going again and wanting to make sure that the jury retains all of the information they've been given so far?
It's not great for your momentum in your trial strategy when you have a 5-day gap when you're presenting to the jury and your cross-examination. So you do probably lose your rhythm in that regard, and you are worried about the jury having to almost re-educate them to some degree. But it's nothing that can't be overcome, and I'm sure they're handling it very well, both attorneys.
And as far as the defense is concerned.
And to that point, fortunately, the delay happened very early in the trial, so there's not a lot of information that had come out already for the jurors to lose retention of. So hopefully it's just a small stumbling block and they can get back up to speed pretty quickly.
The big focus of the trial is this conspiracy to kidnap charge. That is the charge that all 4 of these men face. In a lot of these recordings, you hear them, specifically Barry Croft and the one that was played yesterday. He's been a big focus so far. You hear him say at one of his meetings, his daughter comes up to him, asks him if he wants anything for dinner. He says, "Honey, I'm making explosives right now." As far as the conspiracy charge is concerned, does that incriminate him? What does that prove as far as the prosecution is concerned?
It certainly goes a long way, again, towards taking substantial steps towards the kidnapping and murder. And so in terms of the attempted portion of the charge, he's taking affirmative acts towards violence. And so that certainly will help the prosecution's case to hear again in his own voice, "I am making explosives." That's very strong. That's very strong evidence.
I think it's important to remember, though, that it doesn't in and of itself prove a charge or a case for the government. But Pat's right, it is something that the government's going to rely on when they try to put together the whole package of information and explain to the jury that they've proved a conspiracy and the overt acts or the steps that the individuals were taking to commit that crime.
And the defense has been doing this a lot. We've talked about this, throwing seeds of doubt across this, and they've talked about Croft being the focus of the investigation. And when he was initially targeted by the FBI says they targeted him because of his language online and his firearms when he wasn't supposed to have them as a felon. But the defense yesterday presented the fact that those charges had been pardoned back in his home state and that maybe it shouldn't have been the focus in the initial investigation or a reason. Does that really have an impact on this case?
Well, I'd like to step away from the pardon for just a second and focus in on the fact that if the defense is trying to show that they were targeted for their speech and their feelings about the government, and that to me is one of the main focuses of what the defense team was trying to do. The fact that the FBI agent then said that he had a gun and that's what made them concerned is a point for the government, and I'll let Pat speak to that part of it.
That's always a very strong way for the government to prosecute a felon in possession of a firearm, and that's always an opening. It's usually an additional charge. In this case, I don't think it is, and so that is something that, on top of the violent rhetoric online, certainly was going to get the attention of federal law enforcement. And so again, for that to be raised in trial, not necessarily an affirmative defense that there was a pardon involved and may have been entitled to carry the firearm, maybe not. Maybe didn't go through all the procedures to restore his full rights under federal law. But again, that's just trying to cast doubt on the way the government initiated this case. Why did it begin its investigation? Was it just investigating people who were talking big bravado, didn't intend to do anything, may not have even had a criminal intent in their mind that was planted, they're going to allege in defense, by government agents or government informants? Prosecutions laying it out in their own words, whether it's online or audio or video, these defendants meant violence and meant what they said.
We've talked about the mountain of evidence that the prosecution is bringing, to over 450 pieces of evidence. Do we expect any surprises at this point? Is that something that either side wants to prepare for, the defense? Most of it's been audio recordings, and we're seeing I feel like we all have a good idea of the direction this is going. Do we prepare for surprises in a case like this?
Any good trial attorney will tell you that there's a surprise in every trial, no matter how much you prepare, no matter how well the witnesses are prepared, there's always a surprise. So lawyers, of course, are going to anticipate potential surprises. So it's hard to say whether there would be a surprise in this particular trial or not.
You would really think with all the pretrial, the evidence, the sharing of the evidence between the parties and the obligations on the government side to produce any evidence that might be exculpatory or let the defendants help their case. You would hope that there wouldn't be any surprises, but like Tanya said, you always prepare. That's always a lawyer in the back of your mind. You don't want to have a surprise, so you want to try and prepare for any contingency. And so there shouldn't be, but right, sometimes you never are fully sure what that witness is going to testify to on the stand.
Okay. Well, much more time left in this trial. We're talking about 4 to 5 weeks. So if there are any surprises, there's still some time left to be had.